Go ahead. Go ahead.
That started.
Good morning, everyone. While you're getting into the room, we'll get started with some brief introductions. My name is Stuart Weinstein, and I'll be going through the writing with respect to the matter involving uh, the Olson matter. And my colleague Wendy Nielsen will be taking you through the research criminal litigation, the famous dogs incident. So,
Yeah, thanks, Stuart. Hello,
yeah.
everyone.
So, a couple of housekeeping rules while you're coming into the classroom. Um, we're going to do it this way. Is what we're going to do is each of us will make our presentations first, and then we'll deal with questions afterwards. And this is allows students who can't stay for the entire session to see the whole presentation, and this way it's a little bit easier for them. And then we'll cover the questions that are in the chat room, the chat box, right afterwards. This way, it's easier to follow, and it's also makes it easier for students to understand kind of more of the presentation as we do it. It's um, just an easier way to do that. So hopefully we've got enough people here, and I think we will get started then. So the the presentation that I'm maybe talking to you about is the issue of the legal writing, and this one is the this legal writing dispute resolution. And this one is kind of an interesting one in the sense that it is a 30-minute computer-based exercise, and it's the um, shortest of the uh, assessments that you are given. And most notably about it is that you have about 30 minutes to look at an issue in dispute resolution and legal writing, and it can be covered any of the areas that are within the scope of the SQE2 uh, materials with respect to dispute resolution. And then they ask you to kind of give some sort of a written letter, perhaps, or some sort of a memo, and then they give you an instructions and template for you to follow. So it's critical that you follow the instructions, and then also be sure that you follow those instructions. And the most important thing to remember, of course, is the time pressure. Um, in real life, um, you don't get to do these kind of quick letters, say in 30 minutes. Maybe you do in many situations, but of course here you're under that time pressure. So the most important thing is to be sure you read the instructions and follow the template, and get started in terms of organizing your thoughts and how you want to get the key points across. So let me kind of take a look at the assessment criteria. And the key thing with respect to the in assessment criteria is that you kind of have it's a um, twin-based assessment criteria. Of course, you have on the one hand you have the skills, and then you also have the application of the law. And um, I kind of always recommend that if you have the time, um, take a look at the performance indicators for these different assessments that are available from the SQE2 materials, and you'll see they kind of give examples of what they're looking in terms of competence and what doesn't demonstrate competence. And most notably in the skill side, including of relevant facts is really critical. And when talking about relevant facts, be sure to work the relevant facts into your analysis. Don't just repeat them, but kind of try to gear the facts to the instructions you're given. Of course, you also want to use a logical structure, and that's important too. Is organization is going to be critical in your presentation. Um, Things should be well organized, set out clearly, and of course, easy to follow. Um, Most critically, number three, we have two number threes here. This will be number 3.1, which is that the advice and the content should be client and recipient focused. Um, you're writing to a client, it has to be set out in plain English that a client can understand. You have to kind of avoid using excessive legal jargon. And then here, using clear, precise, concise, and acceptable language, which is appropriate to the recipient. Most notably, it has to offer clients options and advise on strategies. Um, Taking into account who the client is and their needs, objectives, and priorities. So in this particular example, you have a client and they've have a county court judgment for £25,000. So if your advice was of such a complicated nature that perhaps the amount of legal fees that you would incur in pursuing your recommendation would be, 30 or 35,000 pounds, then the advice you're giving is not really appropriately addressing the client, the situation, and is appropriate. So always keep in mind your solution should be practical, practical. And then, of course, you have to correctly apply the law. You have to identify the law that's correct to the client's situation, the correct legal principles, and apply them to the facts. And then, of course, you have to apply the law comprehensively to the client's situation, identifying ethical and professional conduct issues, and exercise judgments to resolve them honestly and with integrity. This last point about the ethical aspects, it's not a guarantee that every particular scenario will have some ethical issues, but if you do spot them and you see the professional conduct issues, be sure you address those in your discussion. So, a couple of suggestions and say tips on how to kind of handle this particular scenario. When you're First thing you're going to do is include relevant facts. So in your introductory paragraph, if appropriate, or referred to as you construct your answer, you might want to go through the relevant facts. Here, the claimant has a judgment against the defendant for £25,000. It remains unpaid from the Central London County Court. The defendant was a litigant in person, did not have solicitors. And you have to then indicate that you understand the steps that were taken already in advance. So most notably here, Mr. Simpkins, he represented himself without solicitors, and he's ignored our correspondence to date. And then always a good idea to repeat what the advice the client asks. So here you might hear the client's asked on what steps we can take on her behalf to obtain payment of the judgment. And that really is kind of key point is make sure that you kind of answer the question and make sure that you kind of repeat the question the client asks in your discussion. And this is comes on to the second point is using a logical structure. And here, it's a letter that you're producing, and you'll be writing to a client, and the letter will follow these particular steps. When you have a letter, you're going to be organizing it in a way that is typical for the letter. Here, obviously, they kind of give you in the instructions information that you would use to top and tail your letter. They give you the name of the client, they give you the client's address, they have a reference number, and you always have to have your subject as well, and they have a subject as well. So those are the things to cover in the top of your letter, and then you address the client, dear Caroline, dear Ms. Olson, a salutation, and then of course, when you have the salutation, it will determine whether it's yours sincerely or if yours faithfully. And if the person is known to you, you would say yours sincerely, or if there is no addressee, or if the person is not known to you, it would be yours faithfully. And most importantly here is that the instructions tell you who the letter is coming from, and here it was coming from the supervisor, and that would be the person who would be signing the letter in this particular scenario. So again, be sure that you focus your letter in a way that the client would want to read it. Logical headings, subheadings, paragraphs, answer and explain, and then closing with the right sort of a salutation and closing as well. So in terms of the substance here, as a general rule, even though judgments are supposed to be paid within 28 days, there is no automatic enforcement of judgment debts. So in this particular scenario, you're going to have to get additional information here in order to organize an enforcement proceeding in this particular scenario. So here, what you're going to have to do is get information to be obtained regarding Mr. Simpson's, who's trading as Pipe Dreams. You'll have to kind of figure out whether he has business premises or stock, and whether that stock is essential or not essential for his business. Because if the stock is essential for his business, you can't touch that. You'll have to also look for money in bank accounts and personal assets. So these are the sorts of things you'll be looking for, and the best way to get this information is through some sort of a procedure for an oral examination. You have already some information that's provided by the client. Most notably, there was some social, and this was kind of some nice facts about them that Caroline knows Mr. Simpkins socially, and she provided some information, most notably that the defendant has got two classic cars. He's a classic car enthusiast. He keeps two old Lotus sports cars in a garage somewhere in South London. And he has a house where he lives with his wife and child. And he also owns a flat somewhere on the South Coast, which he lets on a short-term basis using Airbnb. So information about registration you don't have. You don't have information about addresses of where the Lotus sports cars are kept. You don't have addresses as to the house where he lives with his wife and child, and you don't have addresses as to the flat in the South Coast. So you need all that information to bring the judgment to the point where it can be enforced. And so that's really kind of the critical issue, is you have to identify that information. And the best way to do that is to arrange for a procedure of oral examination. And that would be the and then after you do that oral examination, you have to identify certain steps that will get the client money they need in order to pursue the remedial works that they need. And this is critical here because you have to have practical remedies that will get the client money right away and not wait for years. Certain types of remedies that you may propose, while they are remedies, they may take such a long time that it won't really help. So things that would be useful would be is the process of getting more details. If you've come up with a recommendation saying we should write a further letter, to Mr. Simpkins, that's probably not going to be helpful in this matter. He hasn't answered previous letters. There's no suggestion that he could possibly would respond to a letter from, say, solicitors. Probably not likely. He hasn't responded in the past. Those key people in the process are the bailiffs. These are the people that knock on your door if you have a judgment against you, but they need information. It's not enough to send the bailiffs out to, if you don't know a location where the property is, or you don't know the location, the residence of this individual, unless you have those details, the bailiffs will not be able to do their function. So the solution in this particular case is, number one would be is oral examination, and then step number two would be get the bailiffs out there and they can do their work in a quick and effective manner once details of assets are known. And then you can do step three would be a charging order on the property. Now, one of the problems with a charging order on a property is it can take a long time. The court will postpone sales on frequent occasions. And especially if you have a situation where the property, he's living on the property with his wife and child, the courts aren't going to take action to dispossess the wife and the children in the process for you to enforce your judgment there. So it's a certain amount of limitations you might stay there in terms of pursuing a charging order on property, and it takes a long time. So that's a long-term solution. Another solution might be is bankruptcy, which is kind of more of a strategic threat. And in that regard, you can possibly suggest, if we don't have satisfaction, we may have to pursue some sort of a bankruptcy route. But the problem with that is that chances are that Mr. Simpkins may have other secured creditors, and they would come ahead of your clients. So, and there are certain costs of the action. So that remedy, while it's in principle a remedy, it won't necessarily ensure that Caroline will get her funds, because she would be an unsecured creditor, and it would be she'd be at a significant disadvantage. So it would be kind of what we'd say is a Pyrrhic victory. Pyrrhic victory with regards to that. So really, the key thing here would be is to get those bailiffs there, to go in there and get any goods that they can obtain. And in the exemplar, they go through a section on taking control of the defendant's goods. And of course, the ones that you really want are the Lotus vehicles. It's going to be a fight in terms of which goods are essential for the business. Probably won't get those, but if you can get the Lotus vehicles and you can be assured that he owns those vehicles, that would be probably the best place to start. And remember, again, if the goods are used in the defendant's business or their household items which are necessary for the defendant's and his family's basic needs, you're not going to get those goods. So really, probably the cars would be probably the best chance in that regard. So remember, again, in terms of the advice, who you're giving the advice to, keep it focused. Make sure that you summarize instructions in the introduction. You give advice on the steps to take to enforce the payment, enforcing the judgment, avoid legal terminology. So here, a suggested analysis might be as you do an introduction, you talk about the oral exam, procedure, compliance, and sanctions. It's done under penalty of perjury. That always gets people to tell the truth. You can then review the enforcement options following the oral exam. And then you talk about the advantages of the bailiffs. It's goods, you get cash, the quickest method. You can transfer the proceeding to high court for enforcement. Then talk about the idea of a charging order on the property or evaluation. The issue of equity in property comes up. The court, of course, can postpone the order for a sale with a house or family. You don't want to make them homeless. There'll be costs. There may be delays in receiving payments for several years. Bankruptcy, there are some advantages and disadvantages, and there are strategic uses to get the defendant to pay would be a good idea. And then finally, remember next steps. Now, here, they don't, in the specific advice, they don't ask for next steps, but I would always recommend that if you're giving advice to a client, make a clear recommendation. And then, of course, at the end, close out so next steps here would be is something like, if you're happy to proceed, as I suggest, I will complete the necessary forms to arrange for oral examination. Please let me know if you'd like me to do this. So it's always good to ask the client a question and have the client then respond to you. And then, of course, you can always give them the option. If you want to discuss the options too, please get in touch and then sign out the letter. And that's kind of the key points there. Most importantly, use plain English. Don't pad. Avoid any type of word that makes you sound like a lawyer, heretofore, therefore, so on and so forth. Just simple. I will now explain the legal position. Use verbs over nouns. Complain as opposed to make a complaint. Avoid technical legal terms. Avoid jargon. Avoid long sentences. And the key thing is this is where students have trouble is sometimes they list options, but they don't weigh the different options. So you're being paid to give advice. Don't just tell them this, you can do A, B, and C. Tell them, I recommend that you take step A, step B. And then also always come up with more than just one option. A range of options is really excellent. You can do step A, or if you don't like step A, you can do step B. And be sure you identify the advantages and disadvantages of the methods as applied to the facts, and always recommend a clear course of action and say why. And always consider whether the client's next steps need to be book an appointment, have a conference call, or confirm. And that's kind of a critical thing. Sometimes students don't cover those points in their analysis, and that kind of they lose points at the end. It's really critical at the end is that you're writing to a person who's not going to be a solicitor, and they won't know whether, what is the next step. So they're expecting you to lead them into the next steps and to kind of say, you know, we want your permission to do X, Y, and Z, and we will take those points forward. So I see that, let me see if I can go to the chat. Let me see if I can open the chat. Hang on.
Would you like me
So,
to read them out, Stuart?
oh, if you can, that'd be great.
Yeah. Rodica, hope I pronounced that right, is saying, this all makes sense. The concern is managing to have all this information included in the amount of time. How do you advise to manage to submit a proper answer in time?
That's an excellent one. I think that you're under excruciating time pressure here.
Yeah.
I would say that start organizing right away, maybe put in some headings to your letter. I don't want to say take 15 minutes to organize and 15 minutes to write. Some people may be a little more organized, but the key thing is to keep an eye on the time. And remember too, is that to do the exemplar that we have is 1, 2, 3 pages single space. Probably 1 to 2 pages is really kind of what you can reasonably expect to get out there in terms of a competent answer. So everyone else is in the same boat as you. So it's really kind of what is humanly possible. But again, the key thing is organization and timing. Organization and timing. If you're a type of person where you always run short on time, put the headings in to get started. Put the headings in and get the simple stuff out of the way and get that in there. But again, it is the time pressure here is significant. Do we need to mention that interest is payable? And also, why do we need to have the case transferred to the high court? I think that in terms of the interest payable, if you feel comfortable to mention that, that's fine. It's not essential necessarily. And probably with the information about whether we need to have the case transferred to the high court. Question, Ellen, is that information essential for your client to know? What would the client benefit from knowing that the case may have to transfer to the high courts? If that information is necessary for your client and she has to make a decision with respect to that, then mention it. But if it's not 100% relevant for the client to make a decision, probably not going to be something that they're going to even understand or kind of appreciate. So, think about that issue there. Certain elements in terms of transferring the case to the high court, there are certain types of processes and procedures which are covered in the materials that do have to go to the high court. I don't want to kind of get too far into that, but suffice to say is focus necessarily in terms of what advice will be useful in terms of the information you want to get to your client. Great. So in terms of the time required, the quickest way is taking control of goods, and the getting goods is the quickest way. The longest ones are charging order, and bankruptcy would be as a Pyrrhic victory in the sense that if you force the client into insolvency, you're going to get pennies on the pound, so that doesn't really help. And the charging order can take years. It's not a quick process. So really the goods are the goods and the bailiffs are the key ones. Sometimes as well as the other thing to think about is some students have come up with ideas like I've seen it in the past where they discuss uh, uh, either attachment of earnings, but in this regard, he's self-employed, so it's not like he has an employer to go to, so that's not going to work. I've seen other solutions being a third-party debt order. So here, maybe if you could identify in the oral examination that he has payments that come in on a regular basis from a client that was maybe owed him money over, and he was paying out over a number of years, perhaps that might help. But I didn't see much evidence here as to anything that would be specifically useful for that third-party debt order. So I think the best would be is to get goods. So we have 30 minutes to prepare. And this is to Alicia, and write the answer. We could not go into so much details, pros, cons, each option due to time straight. The SPA seems quite, yep, there's no doubt about that. 100%, Alicia, you're 100% right about that. Yeah, 3 pages like this in a half hour, it's not doable. But what we're trying to do here is to try to give you, it seems more like a CMA. Yeah, I think what we're trying to do is give you the information. And yeah. So what about getting funds from a bank account directly? You could get funds from a bank account directly, but you'd have to identify that bank account and see if there were funds in there. And that's kind of the point there. Uh, Interest is payable, and then the point that we covered about the high court already. So I think we covered all the questions. Oh, yeah, mention transferring to high court as the judgment was obtained from county court. So simply explain, as it exceeds the 600, we can transfer the high court for a writ of control in case they query why it's not going to the county court. Don't need to quickly state this point, but came quickly. No, that's perfectly fine, Alicia. That's perfectly fine. No problem in mentioning that if it's relevant to the client's information. So I think those are kind of the key points, and I think it's exactly almost 9:59. So if it's okay, Wendy, I'll turn it over to you.
Thank you very much indeed, Stuart. Thank you. Very interesting presentation there. I'm sure everyone will agree. We're turning our attentions now to a rather sorry tale of animals being kept in bad conditions, which I hate to hear about. Yeah, so let me share my screen with you while we go to that particular scenario. Yeah, so this is legal research, as you know. let me go to the first slide. Well, as you all know, computer-based, 60 minutes in total, which isn't a very long period of time to actually get all this done. I do appreciate that. So you've got to keep an eye on the clock at all times. You would normally get an email from your supervisor or something like that, asking you to look into various problems or maybe one problem, and then you get your sources as well. And what you're aiming to produce is an advice, a written report, which includes advice, legal reasoning. And as you're all, I'm sure, aware that previously that was done in two separate sections, section 1, part 1 and part 2, the advice being in part 1 and the legal reasoning, sorry, the resources in part 2. However, now this has been amalgamated into one main section. So everything goes into that main section, which is obviously, I think, quite a lot easier. So I don't think there's really much of a problem there. You will have seen, I think, on the resources page, we look at it in a moment, that there has been an addendum done for this particular scenario, which shows your advice or report all done in one section. Okay, so we will look at that in a moment. So what do we need to actually do in relation to this particular assessment? Well, let's look at the skills that you need to use. Very important that you know the assessment criteria. So you have to identify all the relevant sources and the information. That's the first thing. You're given a series of sources. In this particular one, I think there are about 6 or 7 different sources, which again, we'll look at in a moment, such as textbooks, which of course are secondary sources, and then statutes and case law, which are primary sources, as you know. And this particular skill that you are trying to demonstrate, it is really to show that you have adequately referenced your report or your advice against the relevant sources and information. So it is very, very important that you get the relevant sources into your advice. And of course, at the same time, the second skill is to provide advice which is client focused and addresses the client's problem. So basically all that means is that you have to answer the client's question or questions and to confirm the applicable law. Client focus, well, what does that mean? I think we've all heard that so many times in respect of not only this particular type of assessment, but in all sorts of other areas as well. I mean, in this particular instance, you will get generally an email from the partner and your answer will be typed into a template, which will normally be an email back to that partner. And even though you are writing to the partner because you're giving him your report or your advice, you would still need to provide that advice, considering the client's issues and addressing the problem that the client actually has. And number 3, you would use clear, precise, concise, and acceptable language. So something that the client will be able to understand is what you need to be creating. And then applying the law, you have to apply the law correctly to the client's situation. Well, that goes without saying. There are a number of questions in this particular scenario, and each has a different sort of aspect to it. So you need to actually reference the advice in relation to the law from the sources. And it needs to be comprehensive. So that means address each and every one of the client's questions, however many there may be. Okay, so approach, sorry. The approach, first of all, read the question. It may sound very, very obvious, But you need to read through and make sure that you have all the elements out of that question. So we're going to look at the question in a moment. In fact, maybe we could do that now. See if I can bring that up for you. Just bear with me one moment. Yeah, can you see that now? Stuart, can you see that, the question?
No, I don't see the I just see the
Oh, okay,
approach.
sorry.
It's just the
Okay,
next
right, I'm
the
sorry. I'll just make sure I'll get that up. Um, just change over what I'm sharing with you. Here we are. Yeah. So,
perfect.
yeah, this is what you're going to get through in relation to this particular question. And I have highlighted the various areas that you need to be looking at here, making the text a little bit larger. So obviously, Mrs. Hannon is running a charity. She's recently rescued horses and dogs from Fogarty Farm belonging to Mr. Tustane. So she wants to bring a private prosecution against Mr. Tustane, and she's seeking advice on whether there are grounds for prosecution. So she's bringing a private prosecution, and you're told you don't need to get involved in the rights and wrongs of the private prosecution itself. Simply the law around whether or not there is sufficient grounds to bring such a prosecution. So make sure that you know what you're being asked to actually write an advice on. And I've actually highlighted in red from here the various aspects of her query. So number one, I've added number 1, 2, and 3, and 4 here, so to make it clear to you that wasn't actually in the email. And highlighted it in red. Firstly, there's 10 horses kept in a field with no shelter. There's no water supply, only empty buckets, and they were malnourished and emaciated. So that's the first maybe subheading that you could copy and paste into your answer. 10 horses, malnourished and emaciated. Okay, so you could copy and paste that into your text on the other side, on the right-hand side. Secondly, 4 dogs were seized. They had their tails bobbed, in other words, cut off above the base of the back. So again, that's the second issue here that again could be copy and pasted across into your answer. Thirdly, as I've mentioned it, number 3, posters were found at the premises advertising dogfight events at the farm with photos of some of the 4 dogs. Entry fees were being charged, and all 4 dogs have injuries consistent with dog fighting, some of them quite serious. So again, that is the third issue, which could be copy and pasted across, or you could just put a little subheading, dog fighting at the farm. Okay. Number 4, one of the horses has a serious bacterial illness, which is commonly vaccinated against, and the horse isn't registered for any medical treatment at a veterinary practice and has not had routine vaccinations, therefore. So the fourth sort of subheading you could make yourself in your answer is horse with serious illness, no vet, or something. You could tailor it later with a better subheading, but that just gives you the 4 issues that you are going to be needing to look at. And it would also serve as a reminder to you as you're going through not to miss anything. Okay, so once you've read through the advice, you've extracted these 4 issues. And of course, here I've highlighted again, you need to advise if there are any grounds for prosecution. You do not need to advise on bringing private prosecutions, so the rights and wrongs of private prosecutions don't enter into this answer, okay? Or any evidential matters. There's simply advice on the possible grounds. So that's making it very, perhaps not simple exactly, because none of these questions are simple, but it's sort of narrowing down the issues that you need to deal with here. So don't get bogged down in something that you've not been asked to do. Make sure that you are addressing the question or questions that you are specifically asked to deal with. So there they are. There are the 4 issues here. And that's what I would expect, that you would read through that. You perhaps read it a couple of times and make sure that you have bottomed out what you actually need to do. Okay, so let's go back to the previous slides. Yeah. Right, so you've read the instructions. What is the broad topic? Well, of course, the broad topic is mishandling, mistreatment of animals generally, isn't it? Cruelty to animals. What is the client question? I'm sorry, I've gone on to the slide before. Sorry, what is the broad topic? What is the client's question? Well, the client's question is, are there any grounds for prosecution? What are the issues I need to address to answer the question? Well, those are the issues that I've just shown you, the 4 issues: the horses in the field with no shelter and no water, the dog's tails being docked, possible dog fighting taking place. Well, I mean, I think it's more than possible, because obviously there are posters up, or you've found posters, there's a charge being made, so it looks as if that's going on actively. And fourthly, the horse which is ill and doesn't appear to have been vaccinated or registered with a vet. I'm not sure whether registering with a vet in itself is going to fall under the Act, but certainly if the animal becomes ill, then you must take appropriate action. So clearly that action has not been taken, and it doesn't look as if there's been any vaccination given, the evidence being that there's no vet registration. So those are the issues. And what I'm advising is add subheadings to your advice as you're going along, as I previously said. Next thing, skim read the sources, primary and secondary sources. And of course, you've got a mixture here, and copy and paste anything that's relevant into your advice under the relevant subheading. And here, the advice is to have a look at, sorry, my slides are jumping about a little bit. Sorry, apologies. Yeah, have a look at the secondary sources first, such as in this particular instance, let's look at the sources. I can bring those up for you in a moment. There we are. Let's look at the sources. Yeah, you've got all sorts of things. Secondary source, Blackstone, Animal Welfare Act, that's a primary source, that's a primary source, that one. This one is as well. And then you've got another reference to Blackstone there, which is obviously a book. So where do we go here? We've got to have a look at these sources and think, well, what, let's have a look. What's likely to be relevant? What's likely to be relevant here? Well, you'd first look at number 1, Blackstone's criminal practice, offences under the Dangerous Dogs Act. Well, it sounds as if it might apply, but really, dangerous dogs, it's usually the type of situation where somebody has taken a dog out and it gets off the lead, it's dangerously out of control, it bites the postman or something like that. So that is really the Dangerous Dogs Act, and also various breeds that are illegal are mentioned in the Dangerous Dogs Act. So that might not really apply to the type of situation you've got here. So moving along to the next one, the new Animal Welfare Act, and this is a secondary source. It's a news article. Let's click that, and let's. I hope you can all see that source. Yeah. So here, it's actually telling you that this is a Bill of Rights for pets. It gives you the penalties, a duty of care for non-farm animals, and a duty of care to make sure the animals have a proper diet and are housed, etc., etc. And here we are. The first relevant thing is that the age which we're talking about here for buying a pet will raise from 12 to 16, and we know that Mr. Tustain's son is I can't remember what age he is, but Mr. Tustain would probably still, he's 14. Mr. Tustain would be responsible for these animals. And here's the first bit of information here that we can see is talking about the docking of dogs' tails apart from working dogs, which clearly these don't appear to be working dogs for the police or armed forces or anybody else. So that's the first bit of information. So we know that that's the Animal Welfare Act. So really that's been helpful, a helpful secondary source. So we can then go back to our sources and then look at number 3, which is the primary source. And here you have information about the Animal Welfare Act, section 3. So, you know, all of this, you can skim read it, is likely to be relevant to your situation here. Yeah, so section 3, a person commits an offence if he does not take such steps as are reasonable in all the circumstances to ensure the needs of an animal, and a person is responsible for a protected animal if he owns it or is in charge of it. Okay, so that is definitely likely to be relevant to the current situation that you're dealing with. And of course, it has to be in a suitable environment. It needs a suitable diet. Of course, these poor horses have nothing in their field. They were malnourished and emaciated. Okay, so that is likely to be a very relevant. Sorry, I'm skimming through this quite quickly because we don't have very much time. Protection of wild animals. Well, is that likely to be relevant here? I mean, you could skim read it, but I mean, these are not wild animals. They're under the protection of Mr. Tustain. So, yeah, I mean, it's probably better to carry on with the Animal Welfare Act, which is here. And of course, this case, you'd need to look at that. And that is also relevant when we come to look at it, because it's a judicial review. And if you look through the abstract, you can see that the Mr. Gray, is he called Gray? Yes, Gray. Mr. Gray was a horse trader, and there were various sentences imposed on Mr. Gray. And looking down, reading swiftly, it was held that the expression knew or ought to have reasonably known was a common expression and required no gloss. This is that the horses would have had some needs to be kept and to be fed and to have water, etc. And if you look down further, the court, let's have a look a little bit further down. Yeah, this was a common expression and required no gloss. It was a purely, here we are, the judge had been right to construe as setting a purely objective standard of care for which a person responsible for an animal was required to provide. So again, that would be relevant to include in your advice. So you need to go back to these sources and have a look through. Again, I don't really think the Dangerous Dogs Act is particularly relevant to this scenario. Okay, so those are the sources that you would need to have a look at. Going back to our slides, skim read through, copy and paste anything relevant into your advice under the relevant subheading, add legal reasoning where necessary, write the client's advice, review and improve. So always make sure that you have given yourself a little bit of time at the end to perfect your answer. And this, I believe, is the final slide, which just explains what I've been saying. Broad topic, the client's questions. Well, there are 4. What are the issues? What criminal offences may have been committed? So the horse is being kept in a poor condition. There was no water supply and empty buckets. They were malnourished and emaciated. So under Section 2 of the Animal Welfare Act, an animal must be a protected animal. And it's defined that the protective animal is either a domestic animal or an animal not living in the wild, but under the control of man, whether on a temporary or permanent basis. So, of course, these horses would fall within that section. Section 3, a person is responsible for a protected animal if he owns it or is in charge of it. And where somebody is 16 or under, then their parent would be responsible, as in this case. Yeah, so the most relevant offence for the horses left unattended would be under Section 1 of the Animal Welfare Act, which defines suffering. So they were caused unnecessary suffering, obviously suffering because they didn't have water, and that would include physical as well as mental suffering for animals. Yeah, so you would deal with each of the offences in the same way. Skim reading the sources, and we can see here which sections are applicable, and it's this case that sets out the test. Yeah, don't forget to answer the question, is the final note of this last slide. And that is, don't get involved in things that you haven't been asked to address, such as the relevance of a private prosecution. I mean, in all likelihood, people do bring private prosecutions. You don't need to get involved in that. I mean, in real life, I think probably what she would do is she would contact the RSPCA or something, and they would launch prosecution against Mr. Tustain in all likelihood. But you haven't been asked to get involved in any of that. You've just been asked to advise on the law. Okay, so I've kind of raced through that. I'm sorry. I just wanted to make sure that I covered the slides as well as a little bit, about the practicalities of what you're actually looking at here. So I hope that you've been able to follow what I've been saying through looking at the various documents that you would have to look at yourselves here. Chat.
Wendy,
Yeah.
I'll read the questions to you. Would that help?
Oh, that would be really helpful. Thank
No
you.
problem. So we have Radhika ask, is it okay if we copy and paste sections of the law into the answer? Or is it best to just reference the relevant article and summarize what it provides? And then Pavel adds, I do the same. Would quite lengthy citations look bad?
Yeah, I mean that's actually true. And if you look at the exemplar Yeah, if you look at the exemplar, you will see that it's been sort of perfected. I mean, the idea of copying and pasting is so that you've got it there and you know sort of, what the relevant law is. And then if you leave yourself time, you can then, knock it into shape a bit better. So you would say under the Animal Welfare Act, Section 3, a person is responsible for a protected animal, etc. So you could paraphrase it, but just for the purposes of actually setting out your initial advice, you could do a bit of copying and pasting and then change it a little bit. I don't know what you think, Stuart, whether you would agree with that or whether you would have a different approach.
No, that's right. As long as you got the right statute section into your answer, that would
Yeah,
be essential. So let me move
yeah,
on to Ella's next question. I was able to
yes.
identify the relevant act, but it took me some time to decide the sources of the Dangerous Dog Act and protection of wild animals are not relevant. Do you have any tips on this? How would you confidently disregard the two sources and move on? That's a good question.
Yeah, that's a very good question. Yeah. Well, that's very hard because you don't know what's going to come up for your criminal litigation, if you get a criminal litigation research question. So that's really very hard to answer.
Mm.
I suppose it's hoping that you would know what what kind of thing was covered by the Dangerous Dogs Act. Um,
Yeah, those are tricky. They call them what
yeah,
red herrings. So
yeah,
yeah,
exactly.
yeah. Sometimes you'll get them, sometimes you won't. But it's
Yeah,
those are tricky. Yeah,
they are
definitely.
tricky. I'm afraid
Yeah.
there isn't really an answer because you just have to, what you could do is to open up that source and have a look. And does it look like the kind of thing that is relevant to what you're doing? Have a read through. To some extent, you'll probably find out straight away that, it doesn't apply.
Mm.
So that's really all I can say, but it's
And that's
very
that,
tricky.
and that's a critical point. Don't assume that everything has to be relevant.
Yeah.
That's critical. So Shinaki says the chapters on the Animal Welfare Act confuse me a bit. Like, did we need to say chapter 45? It was not on the exemplar, but I was confused whether it needs to be added. And then someone else
I don't think you
agrees.
need to put the chapters in. I think it's probably better and simpler to just put the sections. As you'll see from the exemplar, it just talks about Section 2, Section 3, Section 1 of the Animal Welfare Act. Yeah, I don't think it's necessary to put the chapters.
And then Shinaki has a follow-up question. With the Dangerous Dogs Act, it talked about breeding dogs for fighting, and I said this might be relevant as he may have been breeding dogs for fighting, but we do not know which breeds were at the farm. I'm not sure whether this would have lost marks.
Hmm, it probably, I mean, I don't know. I mean, I wouldn't have thought it would have lost marks. It's a thought. I mean, he may have been breeding them. Yeah, I mean, you I don't think so, but I mean, you're probably better off, always looking at the actual facts you've got. So we're not told he's breeding dogs, and you might be wasting time. So I wouldn't have thought you'd get a negative mark, but you might have wasted a bit of time that would have enabled you to get a positive mark somewhere else. So that's what I'm saying about, if you look at this slide, the last point is don't forget to answer the question. Well, yeah, I mean, the question is in relation to dog fighting, and there doesn't appear to be any evidence that he was actually breeding any dogs. Hope
And,
that
and
answers the question.
and that was one of those kind of red herring kind of things that we were raising in that context.
Yeah.
Yeah. So JR12, should the focus be on referring to the primary sources within our report and the secondary sources are more used to give us some initial ideas and a starting point? And someone else agrees with that one. That's a good
I
question.
think that's right. Don't you, Stuart? Yeah.
Yeah. I think that's the
Yeah.
key thing is uh, I think I think what we've said in other contexts, if you have a reference to a book or something, a very general source or the newspaper article, look there first because that might get to the crux of the issue right away. But of course, that's not going to be something, may not be the most precise information to
Yeah,
cite, in a
yeah,
research scenario.
yeah, yeah.
Ah, here we go. Another question. Alex, is it fair to say there will always be a relevant primary source to back up our answer?
Um, I can't imagine that there won't be. Um, you mean because I mean they can't give you a question that there isn't. Hmm. I don't know. I mean, I suppose it's possible, but I wouldn't have thought so. Would you, Stuart? That
No,
there
I
would
think
be something there wasn't. There wouldn't be.
I think you
Yeah.
could fairly assume you'll have a statute. Maybe
Yeah.
not cases, but statute for sure, I would think.
So
I'd be,
Yeah.
I'd be,
I
I'd,
would think so.
yeah,
so
yeah.
what I meant was more like, even if we are given an article that references primary sources, if we are to rely on it, we will be
Ah,
given
that's
the
a good,
full kind of statute with the relevant clauses. Or will there be any circumstance potentially where we have to quote primary sources but relying only on a article or kind of textbook or something like this?
I got that.
Mm,
I can't
I
imagine that
doubt it.
scenario. I can't imagine that scenario where they would cite a primary source in say an expert text or something or in an article and not give you the primary source. But
Yeah.
if that were the case, I would point out that you this is the cited statute. I haven't had a chance to review the statute, but I can't imagine that because I don't think it would work for this type of scenario.
Exactly. Yeah, I agree with that. Yeah,
Yeah.
Thank you.
100%. Yeah. Are there some more? Let's have a look.
I think that's it. Oh, here you go.
Oh,
Ellen, I did
Helen.
not break down my analysis by the four issues. Instead, I gave a summary of the issues at the beginning and set out the grounds. You think that is okay?
I think, Ellen, it's better and clearer to whoever's examining your work if you did break it down into four issues and you gave sub-paragraphs, as is the case in the exemplar. I think that would be a better way to have done this. Okay, I mean, you can summarize the issues, but it all gets a little bit lost, doesn't it? And if you structure your advice or your email to the partner in such a way that it's clear what the issues are, you're less likely to forget yourself to actually deal with issues if you outline them in a structured form with subheadings. That's my
Yeah.
opinion.
No, I think that's right. I would break them down by issue by issue.
Yeah.
Thanks. That's good
Okay.
advice. Great.
Okay.
And any other questions? I think that's it then.
Okay. Well, thank you very much then, everybody.
Thanks so
Really
much.
enjoyed doing this workshop with you, Stuart. And yeah,
Thanks, Wendy.
wishing everybody all the best in their mocks and their final exams.
Cheers. Take care, everyone. Bye-bye.
Bye-bye.